HR might go along with it and say, okay, yeah, I mean, they're violating our attendance policy, right? But what if those absences were for protected medical leave issues that an employee has their 12 weeks entitlement to under FMLA? All of a sudden, you have quite literally terminated somebody because they were using protected medical leave. The problem was you never knew that it was protected in the first place. Most companies believe they are FMLA compliant. Most are not. One misstep in the certification process could open the door to serious legal exposure. Hey there, my name is Alex Castro. I'm a labor and employment attorney with AXC Legal based out of Fort Lauderdale, Florida. Everything that we're going to talk about, it's not legal advice. It's general information about what the FMLA is, what it requires, how companies get in trouble with it, and what you can do to make sure you don't get in trouble. You might have heard of FMLA. It's the Federal Family and Medical Leave Act. This is the law that gives us what we kind of now know about of 12 weeks of medical leave. One of your employees is dealing with some medical issue and they just need time off to recover. On its face, that's all the FMLA is. Beneath the surface though, it's probably one of the most complicated labor and employment laws that exist out there, filled with technical requirements on really niche, really specific issues that if you are just not privy to, you're gonna breeze on by them without realizing you landed in a compliance landmine. Generally, there's two types of FMLA leave. There's continuous FMLA leave and there's intermittent leave. The other type of FMLA leave is intermittent FMLA leave, which is the far more complicated kind where so many employers get themselves in trouble because they don't realize what is actually FMLA regulated and what is just an employee being absent for a little bit of time. Intermittent leave is exactly what it sounds like. It is leave that an employee needs that is in intermittent time gaps. So this might be a situation where an employee has some medical issue going around, but they can still work generally, and maybe they just need some time off here or there to deal with something. Maybe it's to go to therapy for a couple of hours a week. Maybe it's to be completely offline whenever a flare-up of whatever chronic condition they may have. Whatever the situation may be, they are generally still able to work, just not all the time. And so the employee is entitled to 12 weeks of time off for intermittent leave, just the same as if it was continuous. Let's talk about a couple of areas where employers get intermittent leave wrong all the time. The first step is recognizing when something is FMLA leave or not. So if I told you an employee had a car accident, they came right back to work, they're still dealing with some things, but they're back in the office next week, and now they just need to take a couple of hours off on Thursday afternoons to go to therapy. What if I told you that that 4-hour block of time that only happens once a week is still completely protected by FMLA and needs to be designated as such? Employee needs a couple hours off a week. They go to their boss and say, hey boss, I've got to go to my doctor's appointment today, so I'm going to be leaving at 1 instead of 5. Is that okay? Boss, who is busy with their own stuff, doesn't even really think much of it and just says, okay, thumbs up. That was still protected medical leave that the employee needs to have and needs to be tracked, but they never talked to HR about it. So right there, the buck stopped with the manager. The manager failed to bring something up that was legally protected, and now HR has missed a ton of compliance stuff. Finally, let's talk about one of the biggest and most expensive traps that employers fall into in intermittent FMLA compliance. FMLA is all about an employee needing time off from work. Now, in this scenario, it's protected leave, right? It's for a medical issue, it's protected by law. But let's say you never quite knew that the time off that the employee was taking was protected legal leave. Well, when employees are not there, managers often think they are unreliable, they can't count on them, that they're not actually performing the role that they were hired to do. And a manager who has an employee who is regularly out and unavailable to them might start thinking, ooh, I don't know that this is the right person for this role. Now, let's say you've got a manager who doesn't quite appreciate or hasn't been trained on when to recognize what may be protected FMLA leave versus just what is an employee being out. They might start building a paper trail. HR might go along with it and say, okay, yeah, I mean, they're violating our attendance policy, right? But what if those absences were for protected medical leave issues that an employee has their 12 weeks entitlement to under FMLA? All of a sudden, you have quite literally terminated somebody because they were using protected medical leave. The problem was you never knew that it was protected in the first place. And what that lawsuit is going to look like, it's going to come with a large settlement check. The gap here is a manager who just wasn't trained properly. So the gap is knowing when a manager needs to step up and talk to HR versus the manager just thinking they're managing day-to-day routine absences that don't actually matter or anything. And when there's that gap of communication, that gap of information, that gap of training on the manager's part, an employer can get in really hot water really quick. And it doesn't matter whether or not you intended to interfere with an employee's right to take medical leave or to retaliate against them for it. Because even if you didn't know you were retaliating and you thought you were just enforcing a blanket policy that seemed like it was legit, you're still violating somebody's FMLA rights and retaliating against them for taking that FMLA leave. And when we're talking about high-level executives or other business leaders, the problems become that much more complicated. If you've worked in corporate America long enough, you know that there is some presumption that you're always going to be on, that you're always going to be available. And if your company is requiring that executives, respond to these emails or show up even though they're supposed to be at home on the couch or in bed rest, your company might be getting in trouble for FMLA interference, because now the difference between what is medical leave and what is working from home becomes that much more blurred. And remember, medical leave is leave from work. It is not work from home. And if anything we've talked about today sounds familiar or it sounds like an issue that you're struggling with, click the link below to schedule a consultation and we'll talk it through.